Hi, everyone. Welcome back to our live sessions. It's been a couple weeks since we did it. From Christmas and New Year, I wish everybody a very happy New Year. There's a lot of things that's going on. This very first live section that we're doing, we're going to talk about the 19-country ban and why there's so many people who don't, I want to say, understand the backstory to this. The success story that we're going to talk about right afterwards is going to be about a green card holder who wanted to get married overseas and bring in her husband. And how do you go about doing that? And why does somebody want to go about doing that, right? And so we're going to walk through that journey. The case just got approved a few weeks ago. It's been a 2.5-year journey. There's so many intricacies in between, and something that very few people actually do, and they consider worse alternatives. So I'm going to talk about a lot of that, and I think it'll be really special. And as always, during these live sessions, feel free to ask questions, whether you're on TikTok, YouTube, Instagram. Let us know, and then we'll be answering those questions for you. And if you had left any questions last time that we didn't get to talk about, we'll answer those as well. Or if you direct message us on any of these platforms, we'll try to answer those questions as well, right? But we obviously prioritize the people who are here presently asking questions. And Galen is here. He's reading through everything. So let us know. The first thing we're going to dive into is the news regarding the 19 countries that got banned. Here's the backstory that a lot of people might not know. You might not know this. And it's the fact that this might be a good thing. If this memo did not happen, if the White House did not issue this executive order, a lot of cases could be denied. But because of this order, the cases might be just pending and people might not be subject to deportation. And I know that's completely contrary to what you're probably seeing, right? You're seeing this memo. The White House is cracking down on these 19 countries. People cannot apply, cannot adjudicate, cannot get visas. And so they're trying to crack down on terrorism. That is such a small sliver of the bigger picture. If you read in depth into the memo, if you know about these countries, if you know about the people who are physically here in the United States applying for adjustment of status, applying for various different benefits, they cannot get a lot of the key documents. And that's because in those countries, whether it's fraud, whether it's abuse, whether it's corruption, whether it's just systematic failure, and they noted it themselves in the White House briefing that maybe 40% of a lot of the applications, birth certificates, school records cannot be obtained. When you apply for benefits, when you apply for adjustment of status, you need to have birth certificates. You need to have various documents in order for you to be granted. If you cannot get it and you apply in the absence of any sort of these memos, USCIS, what do you expect them to do? A lot of times they have to deny the case. You could file a motion to reopen, you can wait, but the process becomes a much more difficult. But because of this memo, it says final adjudication will be paused, meaning you can still apply, and now your status is pending, and now you're eligible and legally able to stay in the United States. We're talking about the past 3-4 years. So again, 19 countries is a lot. Every single one of these countries have a different backstory to the United States. I'm going to focus on Afghanistan, arguably because they're listed first. So many people from Afghanistan had to flee and come here and file, and a lot of them got their green cards, a lot of them are still applying, but throughout that entire wave of people who are coming into the United States and who filed it, a lot of them couldn't get these documentation. They filed it and the cases had to be denied, and then now people are doing motion to reopen. So there's a whole backstory to why this memo is actually beneficial, because now you don't have to go through the process of being forced to be denied and filing a motion to reopen just so it could be adjudicated by discretionary measure, right? Because that's the circumstance. Now, you ask, why are we able to even do motion to reopen? Well, because the wisdom of immigration law allows for, if you don't have a primary document because of your country condition, you can use secondary documents, you can use affidavits, you can explain. And we've done plenty of cases where you couldn't get the birth certificate because your country wasn't even formed yet at the time when you were born. You were born in a manger, for example. You just couldn't get the key documents. Well, does that mean, you weren't born? Absolutely not. And you can still get your green card. But A lot of times people who are filing these applications, they didn't have the proper help. They were doing it very speedily. It was a nonprofit, intern that was doing it. And so they couldn't prepare all of these documents. And the case had to be denied, and now they spend a lot of money. You do motion to reopen or else you're unlawful. It becomes a big nightmare. This memo actually helps a large group of people who couldn't get the key documents in order to file. The second thing is, if you really look into the memo, there's a lot of exceptions. So, for example, a lot of our clients right now haven't filed yet. This memo came out. What do you do? It says it's paused. Do you file or do you not file? Well, part of the exception is if you have dual nationality and you have a citizenship from a different country that's not banned, you can apply. Now, yes, that might only apply to Department of State, but why can't we use that to argue in front of USCIS and apply for a waiver? So that's number one. Number two, if you have a national interest in the United States, right? If you are a key benefit to the United States, if you have work, you have various things that can benefit the United States, those are very helpful, and you can argue that as well, and that might still qualify you. So yes, the White House, as well as the State Department, as well as this government is cracking down on the 19 countries. They issued the ban January of 2025. They reissued it January 2026. It's going to affect. It becomes a lot more strict. It's very difficult. I understand they are doing their best to keep United States safe. But if you are already here in the United States and you are not a threat and you have good claims, don't be deterred. Don't let that fear paralyze you. Still prepare a good case, read into the memo, understand what your rights and privileges are. They're not trying to ban everyone. If you are beneficial to the United States, that is something that you can still make an argument for. The last thing I want to talk about the 19-country ban is, if you're part of that, read through the memos very carefully and see which exceptions apply to you, and you can still apply for that. Don't apply for the mandamus. The last thing I want to share about it is, this is just one way this administration, this White House, is clamping down on immigration. But there are so many other tools and mechanisms that are in place that are moving forward as well. And so this is not the only thing to be on guard for. Even if you're not part of these 19 countries, you might be a country that now you have to pay for $10,000 to $15,000 bond before getting a tourist visa to come to the United States, right? Effectively banning all poor countries to ever come to visit the United States. That's another mechanism that is being rolled out, right? And then social media scrubbing is another way to kind of adjudicate and take much longer to adjudicate these type of cases. So there's a lot of things that this 19th country is triggering. But if you're already in the United States, like so many people from Afghanistan in the past few years, right? A lot of USCIS officers were poured and pulled to adjudicate those type of cases, and people got their I-130s and 45s approved, and now they're going to re-adjudicate a lot of these. But you're already here. Prove your case, because before these memos went out, cases were done arguably haphazardly. USCIS in the past 4 or 5 years has been in a state of chaos with being understaffed. And so now it's just taking their time to re-adjudicate. I know it's troubling, but in many ways, like the people from Afghanistan that got their green cards in the past few years, a lot of them got it 10 times faster than many other people. And now you're just being adjudicated again. So don't take it as an affront to you. It's just the system trying to correct itself. So it is very broad. I feel like what I see on TikTok is people either super against it or super for it, but nobody's talking about the people who are stuck in it. And the people who are stuck in it, the people who are here, who have applied, it might benefit a lot of people because now their case is not going to get denied. They don't have to spend more money. They don't have to do a motion to reopen because it is, now it's just paused, right? But they still can apply and they can still stay. People who are outside of the U.S., or people who want to travel, then it's a clear sign, please don't. Imagine if this memo didn't go out and then you traveled and you came back in, and then now CBP officer with their own discretion of national security blocks you, cancels your visa, and kicks you out. You weren't given any notice. This is notice, right? And so I just feel like media and what I see on TikTok is just people who are extremely opposed to it and people who are super happy for it, and both parties, I feel like, get it wrong. I see there's a lot of questions. Galen, go ahead.
So 751 denied and reopened after motion to reopen. It's now pending. My 751 is now pending. Is it okay to travel?
Well, let's see. When you say, is it okay to travel, I'm assuming, is it okay when you come back to the United States, and will the customs officer let you in? Because you can leave, nobody's going to stop you. But when you come back, this is what the CBP officer will see. They will see you previously filed it. They will see that it got denied. They will see that you filed the motion to reopen and it is reopened. But unless you have documents to prove you are eligible to enter the country, they will stop you. Meaning, if you file 751, is your green card still valid? That's key. Maybe it isn't. Most people it isn't, because you're waiting for your 2-year green card and then you file the 751. So did you get a new receipt notice, and that shows that the receive date and the approval date and the pending date, and it's an extension of your green card? Do you have that? If you have that, a good officer will let you in. A suspicious officer might ask a few questions about your marriage or lack thereof. And if you're able to explain to them and they believe you, they will let you in. It is not their position, their job to adjudicate whether your marriage is real or not. That's up to USCIS, but it is their discretion to see if you have a valid document. Now, if you don't have it, you might have to apply for the I-193 waiver, but that's a separate story. So that's a long-winded way of saying you still have to prepare. You have to have the key documents, just so you know exactly what are they looking for.
212F and a partial ban, I assume on my country. If the U.S. spouse moves abroad, does that case restart or resume after the ban?
One more time.
Yeah, 212F, partial ban. If the U.S. spouse moves abroad, will that case restart or resume after the ban has been lifted?
It will restart. So you don't have to file a new one. Everything is in the government already. It's just nobody's looking at it. It's just on a shelf. They're not denying it. They're not approving it. It's just there. And so once the ban gets lifted, who knows when, maybe 2 years from now, 3 years from now, if it gets lifted, then it continues to move forward. And then once it gets approved, then the consulate, then so it will essentially restart.
Does immigration look at what happens in a family law case if there's a pending removal case?
Yes. In a removal proceeding, it depends on what your arguments are. If you're arguing a lot of equities, for example, family ties, for example, you're trying to argue that you've already filed I-130 and the 45 adjustment status is pending, and then in a family court matter, there's kids involved, all those evidence can be brought into the immigration proceedings to support your equity claims, whether it's for a bond or for the cancellation or removal, right? So everything is valid, but, criminal records in the criminal court, valid as well.
What questions can be asked at Ciudad Juarez interview?
What questions are usually asked?
Yeah, or they said can be asked, but yeah, usually asked as well.
Can be asked by the officer. The officers can ask about everything. So there's no like, oh, this is a discrimination if they ask me that, or they can't ask me about my sexual orientation, or they can't ask me about my tattoos. They can ask about everything. Now, what do they want to ask most about is about the core of the case. They only have maybe 1 minute, maybe 5 minutes to interview, and then they have to make a decision. They've already spent 10 minutes reviewing your DS-260 and knowing the basic information about you, and they know all the other people who have applied in similar situations who have been denied and have defrauded the U.S. So how are you different? How are you true? How are you good? How do you make America safe? How do you make America strong? How do you make America rich? That is what consulates care most about. And so when they're interviewing you, is this a real marriage? Is this a real bona fide relationship? Or do you have any disabilities? Are you going to be able to contribute to the United States? What do you plan on working? What is your history? Where did you graduate? It's a person-to-person interview, but that's what they care most about in the back of their mind. So prepare well, explain it to them so that they understand. To leave nothing confusing, leave nothing ambiguous, because ambiguity to the officer, then if it's confusing to me, I better deny it. You can reapply.
Can I apply for N400 on a pending 751? I'm eligible under the 5-year rule.
Yes, you can apply for N400. During the N400 interview, the officer will likely go through the entire N400 process, but not approve it, and say it will depend on the 751. Once that case gets approved, then they will approve the N400, but at least you already passed everything. That's one potential option. The second potential option is that the N400 officer, if they have the experience, they might just adjudicate the 751 right then and there. So you get double approvals on the same, interview, 751 and the N400. But the answer is yes, you can apply for N400 and it will push your 751 to be adjudicated faster.
So this is a follow-up on the pending removal with a family court.
Yeah.
So there was basically a restriction on visitation. So the parent who is currently being pending removal was restricted from visiting their child due to a crime. They threatened to kill the child. Okay. Will that factor into the removal case?
So obviously, in the removal case, the parent who's being removed will not want to bring this up, right? That's not an equity that they're saying, hey, look how close I am to my kids. So you're asking if the government will see this and say, this is a threat to public safety. We definitely need to remove them. So that's on the government side. If they have, if they do their job well, they see the arrest record, they see the temporary restraining order, they would probably bring it up. But in these days, it's so much harder to get an approval. So even if the government doesn't use it, it's quite difficult to get somebody out of deportation proceedings to win the equity, right? So it's already such an uphill battle, right? If you're already fighting Bowser, it's like, is he going to use this extra block? Well, he could already shoot fireballs, right?
So what is an individual hearing like for the Ciudad de Juarez interview? What actually happens?
You go to the interview, you give the packet, you sit in a big room just like DMV. There's like 15, 20 windows, and you wait for your name to be called. That officer already reviewed your application 10 minutes beforehand, and then they call you up. The person who's interviewing you, they might be there for 2 years. This might be their first job. This might be their second post, and they are interviewing you just like they're interviewing everybody else, and they want to know the core of your documents. They want to catch fraud, and it's going to be about 15-minute interview, maybe, right? But in their mind, they're trying to make a decision. They have a lot of authority. And so, a lot of people think, oh, these officers are just like peons. They're just like listening to the higher ups. Decisions are already made. My destiny is already sealed. Doesn't matter what I do interview. Completely wrong. Your fate, not sealed until after that interview, right? So how you prepare for that interview is critically important. Know your application in and out. I highly recommend against lying to the officer. A lot of times they see that. And so prepare well, know what you're saying. And if you need to apply for a waiver and things like that, that's obviously a separate thing. But if you have a clean case, dress well, speak fluently, and again, know that the officer is trying to catch fraud, and how are you going to be benefiting the United States is a very key part of it.
I went in for an interview and I didn't get true. Waiting for my 120 days to be up.
Say that again?
Went in for an interview, didn't get true, maybe didn't get approved.
Okay.
For my 120 days to be up.
Yeah, I don't know. The question is meaning.
How long to get a green card delivery after entering the U.S.?
Okay, I'm assuming you got your visa approved overseas. You got the visa in your passport. You're flying to the U.S. You gave your packet to the CBP officer. You entered, you got home. How long? Usually a month to 2 months. If it's beyond that, something probably happened. You should definitely contact USCIS hotline.
My I-130 is approved. We no longer have a lawyer. The husband is in the U.S. Can the husband apply for an I-45 without a lawyer?
Yes, but it depends on you if you qualify. So look into the 485 form. They'll list a whole bunch of things. If he entered legally, like with a visa, and was admitted, and he's married to a U.S. citizen, that's under, he should be filing the adjustment of status under 245A. And if he qualifies everything, he qualifies everything else, he could totally apply. USCIS makes it extremely easy. And let me qualify that. USCIS makes adjustment of status easy relative to every other country in the world. Okay, if you compare the U.S. immigration system, when you have a arguably clean case, they provide you the forms, they provide you the instructions, they provide details. We're in the internet age, we have chat, AI. There's so many things that you can do. it is still much more difficult than a mortgage application. It's much more difficult than applying for a driver's license, right? You're getting a green card, not just like the, right to drive. So it is difficult, but in comparison to every other country, trying to be a citizen or a green card in another country is relatively clear. So if you're sophisticated, without a lawyer, totally should be able to do it. And there's also a lot of nonprofits and information online, and you could totally do it. And if you don't feel secure, just do a consultation with us or anyone else. We could give you the guidance.
Now,
right?
The wrinkle is they want to apply for this 485, but they entered it legally, unfortunately.
Oh, well, then you can't qualify for the 245A. You might have to qualify for something else. 245, 245K, which probably don't apply to you. You might have to apply for a waiver. You could still apply without a lawyer, but now suddenly the difficulty has just doubled or tripled. But it's not impossible, right? You might have to apply for a waiver, 601A maybe, 601. Take a look at that, research it, and if you have any questions, right, definitely reach out to somebody to consult.
What can an attorney do for someone who is denied a bond based on the new regulations by DHS on EWI cases?
Well, it's in a sense mandatory detention, right? And so it's hard to apply for another bond or try to win a bond, but you could try to win it on the merits, right? I constantly see news approvals and news flashes of people who have been denied the mandatory bond, but then they win it in immigration court and they get out, they get the green card. So it's like, what? I can't get a bond, but I'm able to get a green card, or I get my case closed and I come out. Like, what does that mean, right? That's just kind of the bureaucracy working.
Is it safe to spend 4 to 5 months abroad with a green card? I plan to file a re-entry permit in August.
So I'm assuming you had got a green card, you left 4 or 5 months, you want to come back and you want to apply for a re-entry permit. A lot of people do that. That is perfectly fine. The officer will look at your past 10-year history. If you've been doing that all the time and you don't have any other ties to the U.S., they might give you problems. But there is that 180-day rule. So if you left for less than, 180 days, 4 or 5 months, you have a good claim that you're coming back and they're filing for a re-entry permit. So you should be fine, but definitely depends on the officers and what you did in the past 10 years.
And is it okay to file re-entry permit by yourself?
Yeah.
By the lawyer?
Yeah, plenty of people do that. It is not the most difficult form. It arguably is one of the easiest. The annoying part about it is not the filing, it's the waiting time, because it's like a year and a half. Is it going to get mailed to your house? Who's going to get it? Are you going to get mailed back? How are you going to travel during the entire process? So the lawyer's job, the key value of a law office or somebody who's doing it for you is not the filling out the form filing, it's the processing of it for like a year and a half, and you have questions, you have concerns, you fall into problems. But definitely, it's not a difficult thing. You could totally do it.
I became a U.S. citizen in 2021, and I traveled to Nigeria, which is one of the countries that was on the travel ban list.
So leaving the country is not a problem. It's getting back. When you get back, you are a U.S. citizen, so they cannot ban you. But airlines might be a problem. CBP might pull you into secondary and question you a lot. And so there's a lot of things that you want to be careful about. I would definitely do a lot more research and prepare before leaving.
Yeah, but I don't think the actual, the text of the memo says no, but it more is the...
Yeah, so definitely be very careful, because we know people who have traveled to a lot of these countries and they have stamps from those countries. They're not citizens of those countries, but because they visited, they did business there, they had a conference there. Now when they come in, always being pulled in, always secondary. So it's a big ordeal. So now as a U.S. citizen, you have a lot of rights, right? So yeah.
Do you need to have an I-130 approval to terminate a removal proceeding? I have no criminal background.
You have I-130 approval?
Well, do you need to have an I-130?
Oh, in order to what?
Terminate a removal proceeding.
Let me answer it this way. Even with the I-130 approval, a lot of cases are not being terminated. A lot of cases are still forced deportation. A lot of cases still require a waiver. So even with the I-130 approval, it does not mean you cannot be deported. A lot of people are still getting deported. Take it one step further. Even with a 45 pending, a lot of immigration courts are still not terminating the cases. They're transferring it from USCIS to the court, so they want to adjudicate it. But the 45, even with the 45 pending, next step, I-130 approved, 45 approved, green card in hand. Do people still get deported? Yes. We just did a case the other day. Client had a green card, still got removed, still had to forfeit, and now well, which is the conclusion yesterday. We're trying to get them back to the U.S. So now, with all that being said, let's reverse that. Without an I-130 approval, is it possible to still get the case terminated and closed? Yes, because I-130, 45, green card, petition, those are all equity claims on the family front. Is there any other form of equity removal, right? U visa, cancellation or removal, 42B, right? So hopefully that's a very triage way of answering that complicated question.
I-751 pending since May of 2 years ago, 2024. I had an arrest record, but it was expunged. I'm scared to apply for the N400. What do you think?
Being scared is right. Don't let it stop you. Let it empower you to do everything you can possibly do to improve your good moral character analysis, right? So expungement, that's a plus point, but USCIS doesn't really care about things being expunged. You still want to know what happened. And then they look at other things. So August of 2025, a new memo came out on the good moral character that they look at your physical presence here, your family's here, your ties here, your community service, right? Your payroll, your tax return, your education, your grades. So do everything you can possibly do to match their criteria and do more, so that even though you have one minus point because of this criminal offense, you have all these other things that make you a stellar individual.
How can I contact you? And are you the right firm for a removal of terminating a removal proceeding?
We probably are not the right firm for terminating a removal proceeding. We are only taking cases that is our own right now that are unfortunately end up in removal proceedings. We are not a primarily removal defense firm. We are primarily a family and business immigration firm. We start the process. We do a really good job at what we do, but removal defense is a completely different category in the immigration world. And so there are firms that are 99% dedicated to removal defense. And so that if that's your issue, I would highly recommend directly fighting a removal defense firm. We cannot recommend anyone, unfortunately, but maybe we will in the future.
I'm an adult, LPR, derived citizenship from mom. Can I still apply for N600 with a misdemeanor on record?
Possibly, right? So so the way to find out the answer is take that misdemeanor, do a good moral character analysis on that to see if that's a crime of moral turpitude, see if that's a deportable offense, see if that's an inadmissible offense, and whatever you get from that. When I say a good moral character analysis, I'm talking about plug it into AI, let it do it for you, and then double check it with an attorney. That way you don't have to spend so much money to do it yourself. But it depends on what kind of misdemeanor to see what else you have, right? It's definitely still possible to get a citizenship. We're human, we have foibles, mistakes happen. Immigration law is understanding, it understands that, but you still need to do your job to prove that despite this foible, I am a American in every way. And in fact, I'm better than most Americans. Do your best to prove that.
I did my N400 interview August of last year and still no decision. Is that normal?
August of last year? Okay, so it's been 4 months. It is much longer than normal easy cases, but it's definitely not the longest compared to others. I mean, most cases get approved within a month after the interview, right? And some get approved within a day. So yeah, 4 months is a long time. I would definitely start checking.
My I-120 was expired. I applied for reinstatement. The college issued an I-120 and I graduated. Now I can't apply for OPT, but I can change university for double masters. What are pros and cons on pending decision?
You had an I-20, you got a new I-20, you filed a reinstatement, it got approved, assuming the reinstatement got approved. And so you're on an I-20, the school doesn't allow you to go on OPT, and now you're going to transfer to a new school with your approved I-20. I don't see what the question is. I mean, that seems to be your only choice if you want to stay in the U.S., right?
I got a removal order for missing a hearing, but I never received the notice. My lawyer submitted a motion.
Question again?
Yeah, I got a removal order because I missed a hearing, but I never received notice of the hearing.
Okay.
My lawyer submitted a motion.
Sounds like the lawyer did the right thing. So you wait to see what they find out.
I got my interview at Juarez. Would they approve it with a misdemeanor?
It depends on how you present yourself at the interview. So it is not a definitive, you will definitely be denied. Ask for clemency, ask for a waiver, ask to be approved despite it, right? Treat the officer like they're a judge. Why do you deserve this green card? Is this mistake so small that it's insignificant? How are you going to contribute to the United States? If you just show up super sloppy and say, give it to me or don't give it to me, I don't care, with that kind of attitude, the officer will probably deny you, right? So don't feel like your fate is sealed just because you have a misdemeanor. You still have the opportunity before the interview to prepare well, to show up and try your best.
2 weeks ago, they canceled my oath ceremony. It was to be tomorrow. Do you think I should show up anyway? I have a clean case, no flaws or anything like that.
No, you should not show up to try to get the oath ceremony. It is a free country. You could show up to volunteer, to cheer, to sell flags, but don't show up and try to get a benefit. It might complicate your case all the more.
Do you do the mandamus lawsuit? I'm from a banned country, so do you think a mandamus lawsuit for these banned countries would get approved?
Nope. I do not recommend a mandamus action from one of these banned countries. So I guess we're going back to the new segment right now, right? And if you have additional questions, feel free to keep asking. Galen will collect all of them and we'll ask more. But now we're going back to the story about the 19 countries. Should you file a mandamus? No, because the executive order is very clear. It stops it, right? You won't get past that final hurdle, right? The idea of the mandamus is saying, the U.S. government, you are doing things too poorly, too slow, and it's a violation of my civil rights. And so I'm going to sue you because you are so bad at your job. Well, USCIS is not doing a bad job because they literally cannot process it because the government has stopped it. Now, you can challenge the executive order and sue the White House saying that that order is exceeding the presidential authority. That might be a lawsuit you want to do, and I'm sure maybe a lot of people are trying to do that already. But chances are it will fail because that's a presidential authority. He did it in the first term, he did it in January 2025, and now he's doing it now. So I don't think you should file a mandamus or sue the White House based on this. But what you can do is try to meet one of the exceptions, right? This memo was well crafted and provides a lot of the exceptions. Why should the government ban everybody else but not ban you? And prepare that. Maybe you're a dual national. Maybe you're not a threat. Maybe you are vital, important to the United States. Provide that and argue it. Will USCIS adjudicate it? You don't know. But at least you could put your effort there and with a hope of winning the case, as opposed to a mandamus, which guarantees a denial and waste of time. So I highly don't recommend it. I don't know if there's any other attorneys that are doing it. And if somebody's pitching you to do it, I don't recommend it.
So yeah, you mentioned he did it last term, right? He had a trial, and that one got struck down. So why is this one different? Why don't we think this one?
Yeah. During the first term, President Trump, during his first term, issued multiple travel bans. Some of it got struck down, some of it went through, some of it was chaotic. But the January 2025 was in place and has been in place and hasn't been canceled. And the January 2026 expanded that, right? And so why? Well, the first time he was inexperienced and he did things whatever he wanted, and there was a lot of poorly written executive orders that exceeded his authority, so it got struck down. But this time, it's well crafted, and so not a high chance of it being struck down.
What do you think the chances are of a case being reopened for the reason that I didn't get the notice, so I missed the hearing?
We see it all the time, at least in the past, right? So the past 20 years, we've seen plenty of, okay, well, you get into good notice. Well, now you got it, so now go to the hearing.
I've applied for adjustment of status for 122 days. I've not heard anything. What should I do?
That's less than 6 months. I think you're fine.
I'm an Afghanistani citizen with a green card.
Yes.
Can I travel to Europe and get back in?
I would not recommend it.
What are AOS processing times these days? I just got back from my biometrics.
What are the processing for biometrics? You just applied for what?
What are the AOS processing times?
So once you file the adjustment of status and you file, and it's about 2 months or 3 months to get the biometrics, and then you wait until you get the interview. But we have seen some cases get so fast that like biometrics within a month and then approval within 3 months. So yeah, some cases are super fast. Some cases are still long, 9 months, a year.
I have a 2-year conditional marriage-based green card with an Iran passport. Can I travel and come back in?
Highly discouraging it. Just similar to the person who's on an Afghan passport and has a green card. I'm just discouraging it because I've been meeting with CBP officers and talking about these different things. And to them, you just put through a huge amount of ordeal for them and for you. And so it's just not safe to travel. You don't know what they will have to do. And these memos are changing by the day, even internally, right? New memos come out, new direct orders from national CBP to local CBP, whether at LAX or San Isidro, they're adjudicating things differently. And so it's the firm's policy as well as my policy. If anybody's on these 19 countries, whether you have a visa, green card, or citizen, we don't recommend traveling at all. And we're not the only ones, right? I mean, all the big corporations that we consult, they're also sending these type of notices, right? So
it's just a risk, right?
It's just such a big risk that we just don't recommend it.
How to handle an asylum interview scheduled while the 485 marriage is pending.
We don't do asylum cases, but this is what I know that I would recommend. Tell the asylum officer about the immigration judge about the pending marriage case and see if they could adjudicate your marriage case on the spot as opposed to the asylum application. And if your marriage case is much stronger than your asylum application, the judge might approve your marriage case and close your asylum case. That will be best case scenario. There's all these other scenarios, but that is what we've seen happen, and that would be awesome.
My husband was deported. If he gets his Cuban passport, will he be able to come back to the U.S.?
I don't know enough about that. Right? I know Cuban nationals have very special Cuban privileges, but we don't do a lot of Cuban cases. Might I suggest looking into immigration attorneys in immigration attorneys in Miami and Florida? They do a lot of Cuban cases, so they might have a lot more insights there as opposed to a California attorney.
Do you offer payment plans?
Ooh, great question. On a select case-by-case basis. Yeah.
How long is it taking to get an interview appointment in Ciudad Juarez?
I don't know. It depends. The right person to ask would be Gabby and Margaret. So if you do a consultation at the firm and you want to review your case and you want to predict and all this stuff, they're the ones who do all of these cases, so they would know off the top of their heads exactly how long things are processing.
I was a resident, and coming back from Mexico, I was kept for 2 hours because of my name. And these people think it's okay to travel?
I guess that's not a question. It's more of a advice against everybody who's thinking of traveling because of their nationality, right? If you're part of the 19 countries that got banned, just know that people who have green cards from countries that are not banned and they're traveling to the U.S., a lot of them get stuck at secondary for hours and hours. So even more so if you're from countries that are banned.
My mom's a naturalized citizen, but she left the country 5 years ago. Can she re-enter without any issues?
Did you say she's a citizen, naturally? Yeah, as a citizen, CBP has very little authority to stop you from entering. So citizens are fine.
I had legal entry, DACA, and in 2008, I was assaulted by my ex. He was put in jail and I had court. Can I adjust status with this info?
You were assaulted by your ex-husband or boyfriend or girlfriend, right? I don't want to assume. So if it's a U.S. citizen, but it happened so long ago, you probably can't do anything. But let's say you get assaulted now by your boyfriend or husband or wife, you might be able to apply for VAWA. But in this administration, current time, the best case scenario is just to get married to a U.S. citizen and file.
Oh, we were never married. He is not a citizen, but he is the father of my children.
Yeah, I think it happened too long ago. I wouldn't file.
How long could it take between a an I-551 stamp and a physical green card?
A 751, 551. Okay, the better way to answer. Yeah. The better way to. Wait, what? Read the question again?
Yeah, sorry, I read it wrong. How long could it take between the I-551 stamp and the physical green card?
Yeah, it depends on what kind of 551. Some people have 551 for decades when their green card gets denied, right? So if you look into EP5 investors, 829s, a lot of their permanent green card gets denied, but they still are 551 indefinitely. So that's not the right way to ask the question. I think the best question is when I'm applying to remove my condition, whether it's 751 or 829, or however you got your green card, how long does it take? And
IR5 category.
It depends on the priority date. It depends on the adjudication time for adjustment status. But it could be a few years. It could be a few months.
How long is VAWA taking after 2.6 years combo card approved?
Yeah, that sounds like it's a long time. Maybe another half a year, maybe another year. VAWA are being extra scrutinized and they're mandatory interviews. So if you haven't even gotten a request for evidence or interview yet, it's just a waiting game.
I just became a citizen, but I saw a video of an ICE agent asking someone if they are born or sworn.
Oh, I haven't seen or heard of that one. Born or sworn,
implying that.
Yeah. Well, either way, it's them just trying to see if you're a citizen, right? So, ICE has the rights and authority and obligation and mission to double check who's here legally and who's not. And so if you're a citizen, that's their follow-up question. It doesn't mean if you are sworn, they're gonna pick you up. It doesn't mean if you are born here that they will let you go, right? It's just a follow-up question. And for you to test if you're lying or not, right? The primary objective to see if you're lying. And you give them the heebie-jeebies and weird feelings, then they're like, well, this person looks weird. Then they pick you up, take you to the office, and then try to validate you from USCIS perspective, right?
Right, but there's no distinction of rights between those citizens.
So yeah, I would not, and maybe I'm being too nice about this, but at least for my personal belief, I don't believe ICE is targeting people, whether you're born as a citizen or you're sworn in and naturalized as a citizen. And then if you are naturalized, then they're going to pick you up. I think if there's any fear mongering about this, I think if there's any media, I think it's in my personal opinion, I think that's overblown. I don't think that's right. I really genuinely believe that when they ask this question, they're just trying to gauge, are you legitimate? Are you lying or not? Right? It's like if you're the campus security guard and you see somebody random on the street and say, hey, where are you from? And then you say, oh, I'm a fraternity. And then they ask you a random question. Oh, is it the Alpha Lambda? And then just to kind of gauge, it's not because they're discriminating which frat house you're from, but it's just see, well, do you even know your fraternities? And if you don't, well, then you're definitely lying and they pick you up. That's my opinion.
Is it safe now to apply for renewal for a work permit? I have a son with muscular dystrophy.
Is it safe to file for a work permit? Yeah. If you have a work permit, definitely apply for one, a renewal if you qualify, right?
Can you help with the process of changing from H-1B to F-1? COS or consular recommended?
If it's a great school, consular is probably fine, right? So for example, let's say you have an H-1B and you work in the tech industry for a long time and now you want to go into and you want to get an MBA. Okay, that kind of makes sense, right? But if you've been here for a long time as a technician and then you go to a school and you get I-20 and you want to come to study in English, probably not the greatest consulate, right? Now, consulate is significantly harder than a change of status. So we would recommend change of status, but doesn't mean change of status is easy anymore, right? Ever since last year, change of status becoming fully discretionary. Even if you meet all the requirements, they can still deny you. So you still have to go above and beyond to prove that you are a bona fide student. So where's your spouse? Where are your kids? Where Where are your finances? Who's supporting you? Why are you studying this? What is your education goal? What's your next step? You want to prove all of that.
I have a VAWA application through my abusive son. My daughter wants to apply for me. Can I do consular pro now?
Run it through again.
Have VAWA application through my abusive son. Now my daughter wants to apply for me. Can I do consular pro now?
Can you do consular processing now? You can have multiple immigration petitions at the same time. So yes, she can file for you. If your parents are a U.S. citizen, they can file for you. If your job, they can file for you. So a lot of people can apply for you. And then once that gets approved, then you can go to consulate, assuming the priority date, and then you can adjudicate based on that particular immigration petition, right? So for example, if you're doing it through your daughter and you're doing it at a consulate, they're not gonna necessarily go into the VAWA application. Unless it is like an asylum application or something where they might have a higher scrutiny and they have to scrutinize whether or not you lied to another immigration officer. But generally speaking, their 95% focus is on the immigration petition right in front of them.
So would you be able to help with this H-1B to F-1 case?
Let's do a consultation first, right? And so, I mean, if you want me to do it, just book the consultation through our website and specify I only want to do it with Joseph. But again, this is something that so many people at the firm, they're all capable of doing. So, business immigration, family immigration, everybody could do it. So if time is of the essence, just look up whichever is best for you, which time slot, and then pay the $250 and then do the consultation. If it's with me, it might be about a week, 2 weeks out, right? But it's not a difficult case. You just want to do it well.
I was brought here at a young age. If I want to get my papers fixed, do I need to go back to Mexico?
You were brought here at a young age. I'm assuming you entered without inspection and you don't have valid status. You could leave and then later on get back into the United States through very different application formats. You could potentially fix your paperwork and get a green card through various methods in the U.S. as well. So there's a lot of different options for you. I do not want you to think you have to leave in order to ever come back. And I also don't want you to think that just because you entered without inspection and you were brought here when you were a child, that there's no hope. There's so many things. So look into waivers, study about it a little bit more, especially with ChatGPT. There's a lot of options for you. None of them are easy. A lot of them takes work, but I believe you can do it.
Is the $250 for the consultation only?
$250 is only for the consultation. But during these consultations, we try to teach you as much as we can so you can just do it on your own, right? So you don't have to hire us to do it.
And then it's a credit too, right?
If you want us to do it, then afterwards we'll give you a quote of what we can do, and then that $250 applies to it. But again, the purpose of the consultation is not a sales call. We will teach you, we'll walk you through the steps. In fact, if you already prepared everything and you're ready to submit it, book the consultation, and then, we share a screen on Zoom, and then we could talk about it and, give you some advice, right?
I live in the U.S. for 5 or 6 years. I have a green card. Should I apply for citizenship?
Run it by me again.
I live in the U.S. for 5 or 6 years. I have a green card. Should I apply for citizenship?
So you want to change that order a little bit, right? If you got a green card and then lived in the United States for 5 or 6 years after you got your green card, then you meet the physical presence test for the naturalization to get a citizenship. However, there might be other reasons why you might be disqualified. For example, if you have, 3, 4, 5 DUIs, maybe you shouldn't apply, right? Or if you're still on parole status, that might not be a good idea, right? So being in the U.S. for close to 5 years after you got your green card, that is one requirement. And if you meet that requirement and everything else is fine, then yes, you should definitely apply for citizenship because green card rights and privileges are being diminished by the second.
How long after being in the U.S. on a visitor visa can I get married and adjust my status?
So that's a very nuanced question. The general idea, general rule is if you file the adjustment of status within 90 days of entering as a tourist, the officer might think you lied to the officer. So that's the first question, right? So to be safe, if you are getting married and you are filing adjustment of status, you want to do it after the 90 days. Now, that's the clear part. The part that's not clear is if you fly in, you could get married within a week, but that depends on what you said to the officer, because marriage tourism is very much a thing. We advise a lot of clients, they fly in, they get married, they leave, and then they adjust status out of the US. They do consular processing. So the marriage is not the problem. It's the filing of the adjustment of status. Now, right, so clear problematic case. You fly in, within a week you get married, within 2 weeks you file adjustment. You're going to have a really tough time explaining why you entered as a tourist.
I have a 2-year green card with extended 48 months. Can I travel to Morocco, which is not on the travel ban list, although if I had to name 10 additional countries, it might be added. It's really hard to say.
Tough. Very tough. I mean, it's a risk, right? And it's definitely a risk.
Because you don't know when they could add new ones. Some of them you only have a couple days of notice before you can't enter again.
Yeah. In this administration, if there's any risk, I just would not recommend it. If it's just a leisure travel, not that important, I wouldn't travel to any countries that are even remotely close. But I'm risk adverse. If you have family there, if somebody's passing away, if it's really important, I understand. Do your best. And if one CBP officer doesn't let you in, try another CBP officer. Try to get paroled in, right? There might be additional ways. So, I would just cancel all plans unless it's absolutely necessary. And then go. And if it doesn't work, then contact us and we'll try to do, a miracle if we can.
Such a shame because it's not banned, right? But it's just the fact that there's so much instability makes that chilling effect.
Yeah. CBP just know, CBP officers are on a heightened alert and they're scrutinizing every case to the maximum. So that is the state of situation, right? Imagine you are at school and the bells are going, the alarm is going, there's an intruder, there's a bomb threat, right? That's the state of America with regards to customs. And in that situation, you say, well, can I go to the library real quick, borrow a book? You're probably fine. You probably won't get shot, but they're in such a high alert that if you're remotely a threat, you get expected to be pulled into secondary. You get expected to, be treated like they're going to scrutinize you. And they might, hey, you didn't bring enough documents this time to prove you're actually innocent. I can't determine, so I'm going to make you fly back, get everything, and then fly back. You just wasted an airfare ticket and you wasted a lot of time, right? And so that's kind of the situation. The success story that I want to talk about today is a green card holder who got her spouse a green card. Sounds simple, sounds straightforward, but this is the situation. A lot of people who get their green card don't want to stay in the United States. They don't love the United States. They have a great life abroad, so they apply for a re-entry permit and they leave. That's just the state of the game, right? Think about how expensive and how difficult it is just to live in the United States. But maybe they got it through, a sibling. Maybe they got it through their parents. Maybe they got it through work. And after living here for a while, it's just too difficult. And so they apply for a re-entry permit and they leave. So this individual have left the United States and they keep on going back and forth, traveling back and forth. And therefore they don't qualify for a citizen because of the 4-year 1-day rule. It might take them 5 years. It might take them 10 years before they can ever become a citizen. But they fell in love abroad. Now what do? Here's what a lot of people do, and this is what they did not do, and a lot of people got in trouble for this. A lot of people will say, okay, well, have your husband fly into the country, right? They might become illegal, doesn't matter, and then you become a citizen and you apply for adjustment of status. Voila, simple. But as we have seen in 2025, a lot of people who have visa overstays, when they get picked up by ICE, when they go to their marriage interviews, they get pulled in by ICE and they get denial and they get mistreated and it becomes very difficult. So overstaying your visa and then just adjusting is not as simple as it was before. We did not advise the clients to do it that way. This is the advice we gave them back in 2023, right? Let me see. This is the advice we gave them in 2023. 3 in April. You guys are in love. You want a green card. Why don't you try out what life is like in the United States, both husband and wife? Because maybe you won't like it, and maybe just stay back in your home country and the wife just keeps on using the reentry permit and fly back and forth. So the husband went and got an international student visa, an F1 visa here at UCLA. Great school, came in, furthered his education. And the wife came in, fiance came in as a green card holder, and then they got married. So they got the F1 visa first, then they got married to be safe. And then we filed the I-130 and we waited for the priority date. After about 10 months, the priority date was open. Then we filed the adjustment of status. The husband graduated, and then we filed, and then the husband got the green card just last week, right? So in total, about from September of 2023, where we filed the I-130, till now, I-130 approval, 45, and then green card interview and approval, right? So if you are a green card holder and you want your spouse to become a green card holder, or you want to petition your boyfriend or girlfriend, but they are abroad, the advice and the strategy we usually do is we ask them to get a proper visa, come into the United States, and then while you're on that non-immigrant status, then get married, then apply for the I-130, then wait for the priority date, and then apply for adjustment of status. Do not just come in and become unlawfully present and then visa overstay, and then in hopes of the green card holder will become a citizen, because a green card holder becoming a citizen is not a guarantee, especially for this client who constantly travel back and forth. And so there's a lot of reasons to deny green card holders from becoming citizens. And if that's the case, then they cannot become a citizen. Then the person is overstaying, and then people are stuck here in fear, right? So we recommend applying for the right visa. And in this case, they were young, they were like early 20s. They want to further their education. Go to UCLA, great school, even if it's an extension program, right? Further your education and then see if you like it here. And then they liked it here, and then they got a job. And then now during the marriage interview, with the job, with the marriage, with, property in the US, they were able to pass their green card application very smoothly. And they were so thankful that they did it this way, because they were scared the entire 2025 with all the ICE raids, especially right in November when people were being picked up during marriage interviews. But they didn't, and their case got approved. So when you do it the quote unquote right way, I don't want to say which way is definitively right? But at least doing it this way, you're not a visa overstay. You filed for adjustment status while you were in status. And that's how a green card holder is able to get somebody else to be a green card holder. Without being a citizen, right? Everybody says, "I'll marry you, a citizen," but a lot of people cannot do that. They don't want to do that. So that's how a green card holder can still get somebody else to be a green card holder without necessarily becoming a citizen and doing it in the United States. Hopefully that's helpful. A lot of people in the world are like this. A lot of people are just green card holders. They're not citizens, so they don't have the rights and privileges of citizens. But this is still a way for people to get green cards through their green card spouses. If you have any questions about the success story, Kathy's team did this. When I say Kathy's team, it is like 99% Kathy. She's just a powerhouse. So she does a lot of these. We're very proud of her. And she just shared this story to me. And she's like, it wasn't that difficult. And I'm like, are you kidding me? Right? This is huge. And then, so just give her a shout out if you ever talk to her. Take care.